Hello, everyone. Welcome to another episode of Coffee Chat, where we take the time it takes to drink a cup of coffee to discuss hot topics in the legal and technology industries in a relaxed and concise manner. So, grab a cup of tea, coffee, or take a walk while you listen. Today, we continue our discussion on the explosive topic of artificial intelligence, ignited by DeepSeek. We'll be talking about key legal risks in AI development and China's evolving regulatory framework.
AI, particularly generative AI, is developing at a rapid pace and has already permeated various fields, including automated content creation, image processing, voice synthesis, and even pharmaceutical research. But with these advancements come concerns about ethical and legal compliance, a global focal point for regulators. China has adopted a strategy of agile governance and targeted legislation, enacting a series of laws and regulations. For example, the interim measures for the management of generative AI services, effective August 15, 2023, and the draft guidelines for AI-generated synthetic content identification provide an initial but comprehensive regulatory framework.
Let's start by discussing the entry point of this regulatory system, the registration of large models. Under the interim measures, generative AI services that directly serve the Chinese public and have influence over public opinion or social mobilization must undergo security assessments and obtain regulatory registration. This differs from traditional algorithm registration in that it goes beyond the safety of the algorithm itself and extends the legality of data sources, content supervision, and other factors. However, if a service uses an API to access a previously registered large model, only needs to follow a simple registration process. This approach lowers compliance costs while ensuring regulatory oversight.
Another crucial aspect is algorithm regulation. Since generative AI relies on algorithms and models, China has established compliance frameworks covering algorithms. Key regulations include the Regulations on the Administration of Algorithmic Recommendation Services, 2021, the Regulations on Deep Synthesis of Internet Information Services, 2022, and the 2023 Interim Measures. Developers and service providers must ensure their algorithms meet registration requirements and address ethical concerns and data security risks. If your AI product includes algorithmic recommendations or content generation, compliance must be a top priority before launching it.
Right, and AI-generated content also falls under the broader scope of Internet Information Service regulations. Laws like the Administrative Measures for Internet Information Services and the provisions on the governance of the online information content ecosystem place direct responsibility on service providers for the content generated. Additionally, many AI applications overlap with value-added telecom services. If an AI-powered service integrates into an online marketplace or an information platform, it may require an Internet Content Provider, ICP, license, or other telecom-related permits. Businesses must assess whether their models trigger telecom regulations before launching services.
Let's talk about data compliance. AI systems go through different data processing stages, each with strict legal requirements under China's data security law and personal information protection law. On model training, companies must ensure that training data is lawfully sourced. Unauthorized web scraping or collecting user data without consent could violate personal data protection laws. 2. Model operation. AI services process user inputs, which may contain sensitive information. Providers must implement safeguards against data breaches and misuse. 3. Model optimization. If user input is used to further train and optimize AI models, explicit user consent is required to prevent privacy violations.
That brings us to intellectual property challenges. One major debate is whether AI model training constitutes fair use. Chinese copyright law specifies certain cases of fair use, but AI training on copyrighted materials without permission remains a gray area. Many rights holders argue that using copyrighted works for training purposes without consent is an infringement. Another question is whether AI-generated content qualifies for copyright protection. The core issue is whether such content demonstrates originality, and human intellectual input. The U.S. Copyright Office has rejected AI-generated works, while a Beijing internet court ruled that users' creative choices in AI-assisted content creation could justify copyright protection.
So, who owns AI-generated content? The law is unclear, but some court decisions suggest that if users contribute intellectual input and personal choices, they may be considered the authors. In practice, AI service providers often state in user agreements that users retain ownership of generated content, while the provider reserves certain usage rights.
Now let's discuss AI-generated content and infringement risks. Since generative AI models rely on existing works, the content they produce may carry elements of copyrighted material. If an AI-generated work is substantially similar to a copyrighted piece and there's evidence of prior exposure, it could constitute infringement. A recent Guangzhou internet court case found that if an AI platform can access copyrighted works and generates images that closely resemble them, it may infringe reproduction and adaptation rights. Moreover, style imitation poses additional legal questions. AI can mimic an artist's painting style or a singer's voice. While artistic styles themselves aren't protected under copyright law, courts continue to grapple with where to draw the line between idea and expression. To mitigate risks, companies like OpenAI, Google, Microsoft, and Adobe have pledged to cover legal liability for users facing copyright claims from AI-generated content.
That raises another unresolved question. Who bears liability for AI-generated content that infringes on IP rights? China's civil code outlines the liability of online service providers, stating they generally aren't responsible for users' infringements unless they knew or should have known about them. But in generative AI, content is created through a combination of user input and automated processes. How much control a provider has over the final output and whether they should have known about potential infringements remain legal gray areas.
Generative AI is revolutionizing how we work and live. However, regulations and legal adaptations are still evolving. China has built a preliminary framework for AI governance, but as technology advances, we can expect more detailed laws and regulations. For companies developing AI-driven products, legal risks span multiple dimensions: algorithm compliance, data security, and intellectual property. Anticipating these risks in advance can help avoid regulatory pitfalls.
That's it for today's Coffee Chat. Thanks for tuning in, and we'll see you next time.